Lawmakers pounded U.S. Attorney General Eric Holder on Wednesday with questions about the Justice Department's secret seizure of Associated Press telephone records and grew frustrated when he said he had limited answers. The seizure, denounced by critics as a gross intrusion into freedom of the press, has created a backlash in Washington. It has also led to questions over how the Obama administration is balancing the need for national security with privacy and constitutional rights of the people they say they are trying to protect. Joining us now from Washington is Julian Sanchez, a research fellow at the Cato Institute, and here in our Arise News studio, we've asked media attorney James Walker to be with us and give us a legal perspective on this issue. Welcome to both of you, gentlemen.
Thank you.
I appreciate this. I think that there are some questions that, in addition to whatever the mistakes were in this policy to have increased scrutiny for these 501c4s that had particular words in them, Patriot or Tea Party, there are some questions that the average citizen should be asking themselves. Is there not? I'll start with you. I see you, I see you nodding your head, James. What should we be asking ourselves, and what does this mean for us?
Well, we should be asking ourselves, does everything fall under a terrorist threat? Can you go into a newsroom and subpoena records and things like that when we really don't know where this undisclosed source came from? This was all triggered by a supposed al-Qaeda attack. And they walked into the AP newsroom under the Patriot Act, which gives broad sweeping rights to the government to take files, to take records. And you got to remember, when the Supreme Court dealt with this in the 70s, we didn't have cell phones. We didn't have text messages. We didn't have the data that we have now. So I think the law has to be narrowly reshaped, if not by the Supreme Court, by the Congress. And I applaud the ACLU for jumping in and challenging this Patriot Act.
Go ahead, Julian.
Well, I don't think this is actually a case that has anything to do with the Patriot Act. As far as we know, these were grand jury subpoenas that were used. The real problem here, I mean, there are a lot of problems with the Patriot Act, but the issue here really is a 1986 law called the Electronic Communications Privacy Act, which, following a Supreme Court decision from the late 70s, gives very limited protection to all kinds of digital records or records about communications that are stored by third parties. So the sad thing is they didn't even really need the Patriot Act to do that. The Patriot Act gives them additional, even more aggressive ways to seek out lots of records. But this is, frankly, the kind of thing that the government has been able to do for a long time. And as technology more and more causes information about us and our communications to be kept in great detail by third parties like internet service providers, it becomes a lot easier to get a very detailed picture of someone's life without having to go through the hassle of showing a judge probable cause and obtaining a search warrant.
Julian, I want to step back for just a moment and talk about specifically the subpoena that the Department of Justice issued to obtain the phone records for the AP. You wrote an article about this, and you raised some questions that we should all be asking ourselves, and I want to speak to a couple of them, and that is, what happens to the information that's been obtained indirectly through the community of interest requests, and then what happens to that information in the future? Can you address those two issues?
Right. So, I mean, unfortunately, we don't know a whole lot. I mean, in part, what matters is how information is obtained. So this is grand jury subpoenas, but there are other tools that are used in intelligence investigations and leak investigations, national security letters, something called a 215 order. Both of those really are Patriot Act creations, or at least expansions. Well, not a grand jury subpoena.
No, not that, but the overall way that they're going about justifying everything under a terrorist attack. They're using the Patriot Act, and they're clearly violating what we know as common notions of search and seizure, common notions of First Amendment as guarded by our Constitution.
However, look, there's national security interests at stake. Now, the question is how you balance it. Because if, God forbid, something happens that is horrific to this country, then the issue becomes, why didn't the Obama administration do enough to protect us as Americans? So it's striking that appropriate balance that we have to look towards. So it's in its infant stage. There'll be a full investigation. I'm sure Congress will tear the lid off of whoever did what, when, how, where. But until all those facts are known and the extent of the threat is known, I think we should reserve judgment on the impropriety, alleged impropriety of doing this.
And Joe, I'd like to add, normally when you have search and seizure, you have to show probable cause, some reasonableness. Under this Patriot Act and under the way it's written now, they don't have to show that. They can actually issue a gag order and say some things without even telling you why and they could gag order your paperwork and require you not to reveal that they took your paperwork.
Julian, I want to bring you back into this. Is privacy sort of on the ropes now? I mean, we just live in this new high-tech digital era, an era of terrorism. Is there any reasonable expectation of privacy anymore?
Well, right. I mean, sort of technology giveth and technology taketh away. You know, technology can help us be more secure and more private, and also remove it. Again, the problem really is decisions going back decades to before modern technology that puts so much information in the hands of third parties that it essentially eliminated that requirement, that sort of said presumptively, if you're storing something with Google or with your internet service provider, you have abandoned your reasonable expectation of privacy in it, and a search warrant is no longer required for investigators to go and look at that information. And so that failure to adapt to the way technologies like the internet work is part of why technology is vanishing. But that's a choice we've made. That's not inherent to the technology. That's a legal decision we've made about the kind of protection that we're going to grant.
Julian, what options do we have then? There isn't almost anything that we can do that doesn't leave some sort of digital trace, digital thumbprint. We're talking about privacy, but what about protection of our information?
Right. Well, I mean, there are things you can do. You're seeing, I mean, I think especially in part as awareness about the urgency of sort of cybersecurity becomes more acute. We're seeing a lot more services sort of crop up that are trying to offer greater privacy. I mean, the U.S. government actually funded a tool called Tor to help anonymize online communications. We're seeing services like Spider Oak and the Strongbox that Aaron Schwartz designed, that the New Yorker just implemented for anonymous, encrypted source communication with publications. So there are tools you can sort of go online and find. Organizations like the Electronic Frontier Foundation compile some lists of tools like that you can use to provide greater privacy, but they are still so far difficult for a sort of ordinary non-geek user to implement in a way that is really, genuinely secure.
I just want to briefly add, no one has said this, but as a former reporter before I started practicing law, I'm alarmed when you go into the Associated Press newsroom or their organization and take records. We operate this country under a kind of guise of freedom of speech. And journalists like yourself, as journalists, you're allowed to have sources and to have records and have things confidential. So what's scary for me as a legal person with a former journalistic background is they went into the AP. So yeah. I wanted to just point that out. It kind of violates just fundamental tenets of being a journalist.
Makes a good point. We're going to have to stop it right there. James Walker, thank you so much for being with us. Julian Sanchez, we appreciate you joining us as well.